Hello, this is John Claydon from Contracts, Claims and Disputes. Welcome back. In this short slidecast, I'll talk a little bit about typical insurances we use on an EPC contract. Before I start, I should say that in this slidecast I have drawn from a number of sources, but in particular Construction Contracts, Law and Management, the 4th edition 2008 by John Murdoch and Will Hughes. As always, let's start with a definition. Insurance is a contract that attempts to balance, that is, allocate risk between two parties. One definition is an arrangement by which a company or the state undertakes to provide a guarantee of compensation for specified loss, damage, illness, or death in return for payment of a specified premium. However, for EPC purposes, this is not really a complete definition. This covers perhaps the first of the two main types of insurance we consider under EPC contracts. These are loss insurance policy, under which the insured is compensated for loss or damage he has suffered, and usually for a predetermined maximum amount. That is, the insured receives the compensation. However, beyond the first definition, there is liability insurance, under which the insurer will compensate a third party where the insured has in some way become legally liable. The insurance cover typically required on large EPC contracts includes a CAR, Contractors All Risks, sometimes EAR, Erection or Employers All Risks, which is loss insurance, employer's liability, sometimes called workman's compensation, which is a liability insurance, third-party liability, which is obviously a liability insurance, and professional indemnity liability insurance. This is a requirement of FIDIC 2017 for EPC contracts, and probably also for a number of bespoke contracts along the lines of FIDIC 2017. And of course, in accordance with local laws, motor and vehicle insurance, which is a liability insurance, and in the case of comprehensive, usually a loss insurance. Additional to the above, there may also arise special policies for marine shipments, which is a loss insurance, aviation risks, also a loss insurance, business interruption, credit risk, etc., which are also loss insurances. The first two above may indeed be contractually demanded, but the last are commercial risk judgments for the company, that is the contractor, and usually taken out only on a voluntary basis. All risks. It is common practice on large multi-facility projects where more than one work is under construction for the owner to arrange all risks insurance for all contractors on site. It is then typically referred to as EAR, Erection, sometimes Employers, All Risks. Where all risks insurance is provided by the owner, employer, it may be the case that the excess, that is, the amount of any claim to be borne by the contractor, is set too high, or higher than the contractor might otherwise have arranged. In such circumstances, it's quite common practice for the contractor to arrange his own cover for the difference. Subrogation. The lovely word. What does it mean? Google gives us the substitution of one person or group by another in respect of a debt or insurance claim, accompanied by the transfer of any associated rights and duties. Better, from Wikipedia, is the assumption by a third party, such as a second creditor or an insurance company, of another party's legal right to collect a debt or damages. In fact, the wiki page is interesting and covers the several other applications of the concept beyond indemnity insurance. Subrogation typically arises in three-party situations, but for EPC purposes, that of indemnity insurance is number one. Indemnity insurance. An indemnity insurer may be entitled to be subrogated to the rights of the insured as against the third party who is responsible for the damage to the insured. The site of Practical Law UK also has some interesting points on subrogation. For example, and of particular interest to EPC folks, there is the case where a contractor, having been paid out by an insurer, steps aside, permitting the insurer to recoup some or all of that money from the third party who caused the loss. Effectively, the insurer steps into the shoes of the insured, acquiring the rights to use the insured's name to proceed against any third party who was responsible for causing the loss, and claim from the insured any sums received by way of compensation from that third party. Note, the insurer has no greater rights than the insured and can only pursue actions against a person who could have been pursued by the insured. Management of insurance. This is important. For the contractor, all policies should be logged and that log maintained up to date. The original policies and certificates should be held in safekeeping and copied to the owner both on initiation and renewal. Safekeeping should ideally be off-site in fire and flood-proof storage. The terms should be well known to the contractor and all events notified to the insurance company and owner and claims made expeditiously. Lastly, thank you for watching. If you've got this far, please like and subscribe. Press the little bell for notifications.